And here we go. Our conversation with Marshall Chriswell this morning. This radio program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of those differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell is certainly that, and he's with us on the line. Good morning.
Good morning.
It's good to have you with us here today. So we're in the month of August, and this is a month that, you get all these observances, and it might be National Boston Cream Pie Day. It might be National whatever month. One of the things that is observed in the month from a legal profession is this is National Prepare Your Will Day. Or month in the month of August. I didn't phrase it correctly, but you know what it is. And that's the subject today. Let's talk about wills. And we've visited this topic quite often in the past, but it's no less important now than ever, is it?
Yeah, August is National Make-A-Will Month, so we always take a minute and talk about the importance of having a will and other estate planning documents. It's just one of those topics that, we have, discussed it a few times on martial law before, but unfortunately, when they take surveys of people all across the country, they find that anywhere between 60 and 70 people don't have a will, haven't done this kind of planning. So it continues to be very, very important.
Yeah, it absolutely is. And we could get into why people don't go about it, but let's talk instead about why they should get themselves their will made up. Number one, it's your money and you've made it, and it's your property and you've earned it, and why let somebody else decide what happens to it?
That's right. So why should people have a will? So there are a whole lot of reasons. As you said, you can control the disposition of assets when you're no longer with us. And that's the obvious one. Why else should you have a will? Well, do you have minor children? If something happened to you, what would happen with the care of your minor children and the management of the funds that you've left behind to take care of them? Who's going to be the executor of your estate? What family member or other trusted person is going to take on that sometimes very difficult role? All sorts of things. If you have a special needs beneficiary, someone that child, grandchild, other person who is disabled and relies on government benefits to live. Well, in those cases, an inheritance can be quite a burden for someone because they could risk losing benefits. So you have to plan properly for that. So there are lots and lots of reasons that people should have a will, but there's one reason that kind of overarches all of that, because we can go through all these different goals and things, but the number one goal that people have whenever they are seeking advice for estate planning to get these things in place is something that they may not even verbalize in our consultations here. That is the peace of mind of having it done. Mm-hmm. So many people come in to my office and say, well, I've been putting this off for a long time, maybe a few years, maybe, 50 years,
Sure.
Hey, I know that I needed to do this. I know that this is important, they say. But inherent in that statement is, this is something that has been bothering them. This has been eating at them. This is something that they know they need to get taken care of. And I can tell when we have our final meeting, when folks come in and sign these documents, there's a look of relief, and sometimes there's an exhale, and I'm glad that I did this, or this wasn't
Sure.
as hard as I thought it would be, and generally people are walking out of that meeting with some peace of mind. So I think that all the technical things and all the the things that we're talking about are important, but that peace of mind is invaluable.
Absolutely. So let's put it this way. It's easy to put off to another day, and we understand that there are many, many people who do that. But one of the reasons for that might be because they think it's a much more complicated process than it really has to be. So take me through that process. From the moment you make that initial contact with an attorney, in this case Marshall Chriswell, until you have a will in place that you're completely satisfied with, is it that drawn out a process?
It's not. Normally, typically what happens is someone calls in and makes, and says, hey, I'm interested in talking with an attorney about estate planning, and we obviously set you up for a free consultation, because the estate planning consultations here are always free, and we will send you out a questionnaire. It's a simple estate plan questionnaire, which just provides me with some information regarding your family situation, children, do you have grandchildren, provides me with some contact information and things, and then also some information about your assets. Do you own a home, and who's it titled to, and do you own any other real estate, and what types of investments and things do you have? I just ask for some a little bit of information regarding those things, and that way you don't have to dig, out statements and deeds and titles to vehicles and all those things. You don't have to bring all that. So you just give me the questionnaire, you fill it out, and you bring it with you to our initial consultation. So it gives us a good starting point for our conversation, and from there, we usually have a meeting that lasts about 45 minutes to an hour is a good typical first meeting, just to get a very good idea of the lay of the land and what your specific goals are. And generally from there, once you leave, I have enough information to begin preparing all of the documents that are needed to put your estate plan in place. And then once those are ready, one of two things happens. Either I complete the documents and you come back in and we have a final meeting to sign them, or sometimes I need some more information. Sometimes we hit a hiccup that I need to talk to you about, and we have a second meeting. But ultimately, 2 or 3 meetings, you have signed, whether it's wills or a trust or powers of attorney or whatever the documents that we need to put in place. That's all done. And the time frame, really from beginning to end for most people, is within 30 to 60 days.
That's not bad at all. Marshall, what are some of the common misconceptions people have about this whole process?
Well, I think one, and we kind of touched on it, is that it's going to be difficult. And that's probably one of the biggest things that prevents people from taking the steps they need to get it done. Is they think I've got to have everything in a folder when I go in there. I need every statement for every one of my bank accounts. I need to know the exact penny that's in my the balance of my retirement account down to the penny. I need the deeds the original deeds for my house, and I need copies of my mortgages and all these things. And it's not true. That should not be an obstacle to beginning the process. Like I said, I ask for a short summary, fill out the questionnaire. If I need more information on 1 or 2 things, and sometimes that happens, I'll ask you for those things specifically. But the process is it's not difficult. It's not overly expensive, and like I said, it can give you that peace of mind.
When we began the segment, we were talking about, and I used the statement, why should you not be the person who decides what happens to your property instead of somebody else? Tell me about what happens when somebody dies and does not have that will in place. Sure.
So if you don't have a will in place, first of all, someone is going to need to, if you have assets, they're going to need to petition the court to be appointed as an administrator of your estate. So first of all, who is that person going to be? If you don't have a will, then obviously you haven't chosen or appointed someone. So your family members have got to get together and decide, all right, who's going to do this. So that there's that, and then once the estate is opened, and we've got dealing with the administration, the assets are going to pass by what's called the law of intestate succession. Intestate is a funny word for means somebody that died without a will. And so this is a law that's Pennsylvania statute. It's made by the Pennsylvania legislature, and it doesn't necessarily comport with what most people would want to happen with their stuff. Mm-hmm. For example, if you are married and you pass away, and let's say you have your spouse has a child from a previous marriage. Let's say you have a child from a previous marriage. You pass away. You have a son from a previous marriage, and you have a current spouse. Most people would think my spouse is going to inherit everything, including our family home and everything. But under the laws of intestate succession, your spouse is going to split everything with your son 50-50. Mm-hmm. That may be what you want it to happen, but I would bet that a lot of people, and I know from talking to folks, is that's not what you would expect to happen. You would expect your spouse to inherit everything from you, and your children to inherit somewhere down the road. But so that the intestacy laws don't necessarily meet what most people would plan for. So that's one example. Obviously, the administration process, if you've planned for it and you've got documents in place, it's much more efficient. It can be much less expensive. You can avoid some inheritance tax. There are things that you can do. So it's you can run into a bad situation without a will.
Yeah, you absolutely can. Now, we have less than a minute left, but Marshall, for somebody who already has a will, how often should they get that thing updated?
So I recommend that at a bare minimum, once every 3 years, we have a phone conversation. That is, you give me a call and saying, hey, we did my will 3 years ago. Let's just talk about it for a minute. There's no charge for this call. Has anything changed for you? And go from there and see if we need to make changes to the documents based on that. But also, if you have life-altering events, if you get married, you get divorced, you have additional children, you start a business, you win the lottery, there are all sorts of things. Mm-hmm. It's a good idea to check in with your estate planning attorney.
Okay, so really quickly, how do they do that with you?
Give me a call at 724-465-5826. Stop and see us in the R&P Cole building here in downtown Indiana on Church Street, or go online to www.westernpalawyer.com.
Very good. Marshall Chriswell, thank you so much.
Okay, thanks. Take care.
It is the voice of Indiana County, WCCS 101.1 FM, AM 11.6.1 FM, AM 11.6.1